In California, there are three separate levels of criminal charges. First, infractions, then misdemeanors, and the most serious being felonies. Infractions are generally like traffic tickets, maybe noise ordinances. They're not really that big of a deal, and the punishment tends only to be a fine. Misdemeanors can include jail time up to 1 year and are less serious crimes such as trespassing, perhaps a DUI. And then felonies are serious crimes. They can include state prison for multiple years. In the state of California, there's three classifications for felonies. The lowest is nonviolent felonies. The next is violent felonies. And the most serious are called serious felonies. And they tend to be grave criminal acts that result oftentimes in serious prison times. In the state of California, many criminal charges are referred to as wobblers. What that means is the same charge could be filed if it's less serious as a misdemeanor or more seriously if it's a felony. The most common wobbler is a domestic violence charge. So domestic violence charges, depending on the seriousness, can be charged as either a felony or a misdemeanor. If you're being charged with a felony criminal case on a charge that is a wobbler, you need an experienced, qualified local attorney to help you to get those charges reduced down to a misdemeanor. Criminal charges can be filed against you in the state courts or in the federal courts. Most criminal charges that people face are in state courts. So in the state of California, most everything that you're going to see is in the criminal state courts. Federal charges are very serious and can have very serious outcomes. 99% of all criminal charges that most of us have heard about are handled in the state level. If you're being investigated for a crime or being arrested for a crime, you have rights. You need to exercise those rights. The most important, you have the right to remain silent. The police can only compel you to give your ID, give your identity, and ask very few questions. The best way to stop an interrogation and to not speak to the police or to an investigator is to ask for an attorney to be present. If you state that you want your attorney present, they are instructed that they should stop any questioning whatsoever. You also have the right against unreasonable searches or seizures. Oftentimes, the cops will ask you if they can search your car or search your house, and people don't understand they have the right to say no. Anytime an officer asks you to search anything, the answer should always be no, and you should always keep your mouth shut. The do's and don'ts of police stopping, questioning, or interrogations. The things you should do. You should show them your identification, identify yourself, and be respectful. The things you shouldn't do: do not resist. You should not speak or tell them much anything. You have the right to not answer their questions beyond your identity, and you should exercise that right. You should not lie, but not answering is not lying. You should never consent to a search, and you should never speak to the police without an attorney present. Know your rights and exercise your rights.